convertible debt instruments. You have myself, I'm a partner, a technician, and I'm head of the corporate team and head of the corporate finance team, and also co-head of the commercial team. And we have Fiona Morris as well, who is one of our senior lawyers in the corporate finance team with me. She and I actually worked together many years ago when we were at Barclays together. So firstly, we just thought we'd take a step back and consider why we are doing this session. We've got many clients who are looking at different options in the convertible debt field, mainly for putting in place bridge financing, or they need a quick, or they're in need of cash flow very quickly. And it's an alternative to equity, which some investors find more attractive. These arrangements have become even more popular in the last 12 to 18 months, given the way the market was in 2023. There wasn't really the appetite for equity financing. So companies needed that help. So an alternative was putting in place a convertible debt arrangement.
Okay, so if we talk about what is convertible debt, in sort of very simple terms, it's debt, so it may be debt under a loan agreement or liabilities under a loan note, where the underlying contractual agreement includes a mechanism for the principal amount of the debt, and more often than not, interest that's stated to accrue on that debt to convert into shares at a future date. That debt in the normal way can be secured or unsecured. Again, it's probably more common that we see these arrangements being put in place on an unsecured basis. The investors tend to be VCs rather than sort of much larger institutional investors. And often the companies are at a stage where they don't have any assets of sort of particularly sort of tangible value, or assets where it's maybe easy to take security for over. And so there's a balance there as to, is there actually commercial worth in taking security? I think quite often it's decided to proceed without it. So in terms of the debt actually converting, again, the underlying contract will provide that the debt converts on the happening of certain events. These are normally subject to sort of negotiation in terms of what is and what isn't a conversion event. The debt may convert automatically, it may convert at the option of the lender, and it will convert at an agreed price. And that price may differ depending on what the particular conversion event is. And we'll come on to that all in more detail later in the session.
So what are the advantages of convertible debt? Well, firstly, as I mentioned before, you get an upfront cash injection. You get that quickly, and because there's fewer documents involved than a full equity raising, because normally you would delay any renegotiation of the Articles of Association or shareholders agreement to when the debt actually converts. It means things are done quickly. So you could put a convertible debt arrangement in place within a couple of weeks rather than a couple of months, or 6 weeks, which is what often a full equity raising could take. Shares are issued at a discount, which basically means that from an investor's perspective, they get a higher percentage shareholding than what they would normally get, because they're getting more shares for their money. The company might have capital table issues, that they might have shares that are difficult to divide easily. So by doing a convertible debt arrangement, you can essentially provide more time to reorganize the capital table, or create a subdivision or a share split, or just maybe redesignate some shares. One of my clients at the moment has a convertible, it's actually a secured convertible debt arrangement in place at the moment, and they're just undergoing a fundraising, and their share capital table is quite complicated. It has different types of ordinary shares, different types of preference shares, and then the convertible debt agreement provides for another class of shares to be issued on conversion. So it's just creating quite a messy capital table. So we're actually just looking at ways in which we can tidy it up, but still ensuring that the existing shareholders are protected in terms of what their goal was from the outset, and what they wanted to get back in terms of their initial investment. Also, because we have less documents involved, normally the cost of putting in place a convertible agreement is much less, at least from the legal side of things, than if you were doing a full equity raising. You're simply doing a convertible loan agreement or a convertible note instrument. And then it will depend on what CPs, so these are condition precedents that the lender requires, but often it can be very, very streamlined. Yes, you will need corporate authorizations. And the reason why you need corporate authorizations is not just because you need the board to approve the entry into these convertible arrangements, but because you are granting rights to acquire shares in the company, that will trigger what we call preemption rights. So that's the rights of the existing shareholders to take a pro rata amount of the shares. So unless they are already disapplied and the existing shareholders don't get those rights, which would be very unusual, then you will need to ensure that you either involve the existing shareholders and give them the right to participate, or you get the necessary waivers and consents from the existing shareholders. Disadvantages of convertible instrument. Well, firstly, you've often got a valuation cap. So if the investor required the valuation cap, and by this we mean the maximum valuation at which the debt would convert, and that's to give the investor some protection, and we'll come on to that in more detail when we talk about the conversion prices. But if they do, then this needs to be negotiated, and again, you'd need to provide for that in the documentation. You would need to agree the price per share with the investor, and sometimes they want to see what we call a fully diluted share capital table, so they can see various scenarios in terms of what their percentage shareholding is going to look like. So this can be problematic for some companies because it might be difficult to predict what the valuation of the company is going to look like. But that's something we can help with. We have a team at Ignition Financial that can help with valuations and share capital tables. So feel free to reach out to us as needed. Other disadvantages, well, the discount. So if the discount agreed, then that potentially can have issues in terms of investors having a large discount. They will then get a higher number of shares, which means their percentage shareholding is going to be even higher, and that will dilute the existing shareholders and the founders even more. So you need to look at that in terms of the level of control that you want the founders and the existing shareholders to retain. Normally, discounts that we see at the moment are in convertible instruments. You would see anywhere really between 10–20%. I have seen one at 50%, but that is in a very unusual situation. The investors put a lot of money in and taking a lot of risk, and essentially it's in the company's control whether they can choose to repay the debt if they want. So it's kind of within their control whether they give that 50% or not. It's not ideal, but when companies have very tight cash flow scenarios, then this is what they get driven to. Then just in terms of the valuation, if the valuation on the qualified financing, because the qualified financing is one of the triggers for conversion, if that turns out to be much higher than expected and the investors don't have a cap, then what might happen is the founders might come under pressure from other from the note holders to reduce the valuation in order to maintain the investors' target percentage. Dilution, I've already talked about dilution, but having more favourable terms for the investors coming in through a convertible instrument could dilute the existing shareholders more. So it could leave discontent among the shareholder base. So you just really need to look at those commercial terms. And that's one of the things that, when you're going out for shareholder approval, one of the things that the existing shareholders are going to ask is, is there any interest on there? Is there a discount? Is there a valuation cap? What's the conversion prices? So they'll want to see those terms so that they can make their own internal assessment as to how much they're going to be diluted. In terms of rights of the investors under a convertible instrument, then they might ask for even more extensive rights than they would have. They might ask for what we call a most favoured nation clause in their documentation, which means that if you then go out and do another round that has more favourable terms, they have the ability to exercise their MFN right and have their instrument amended to get those more favourable terms. So that can just provide more admin issues and cause headaches among investors. So these are all things that, from a commercial perspective, you have to think about when looking at your current shareholder base and the investor base coming in.
Okay, so just moving on, we thought we'd just do a very quick summary of sort of the key clauses and terms that you'll see in both two most common kind of convertible instruments that we see, the convertible loan agreement and convertible loan notes. So convertible loan agreement is essentially a contract between a borrower and a lender. You may have multiple borrowers and multiple lenders, but most commonly we see what we refer to as bilateral arrangements, being one borrower and one lender. So under the terms of the convertible loan agreement, the lender will, provided that the borrower is in compliance with its terms, be contractually obliged to lend, a certain amount of a facility. The loan agreement will set out what the purpose of the lending is. And it is for the borrower to ensure that they use the money in that way. Lenders won't usually have any obligation to monitor the use of the loan funds, but often it will be an event of default if a borrower uses funds other than as stated in the loan agreement. The loan agreement will also include a series of conditions precedent. These are certain documents and information that a borrower needs to supply to a lender before it's obliged to lend. How extensive this exercise is quite often depends on the relationship between the incoming investor lender and the borrower. If it's an existing director or shareholder who's lending on a convertible basis, you may see a sort of very basic set of conditions precedent, basically being the corporate authorizations needed to enter into the loan agreement. If you've got sort of a new third-party investor, they're likely to have done more due diligence in relation to the company. They'll maybe looking for, financial information to be delivered, other reports in respect of the operations of the company, essentially everything that they need to sort of back up the due diligence that they've done to ensure that the company that they think they're investing in and the story that they've been told by that company is true. The agreement will then state how that loan can be drawn. Usually this will be on delivery of a drawdown request to the lender on a certain number of days' notice. And once that notice is served, it's irrevocable. So a borrower can't sort of go to a lender and say, oh, I'd like to draw down 100,000 now, and then the following day, so actually, no, I'm not going to do that. So once drawn, that loan's going to be advanced. Interest. So interest under facility, which is essentially the payment to the lender for them from making that loan available. This can be charged on the basis of a fixed rate. So for example, just a flat 5% per annum. It could be charged on a floating rate, being a margin. So for example, 5% over base rate. So as the base rate fluctuates through the life of the loan, so does the overall interest rate payable on that loan. Or the loan could provide for a variable interest rate. And sometimes you see this where if companies hit particular milestones or are compliance with particular covenants, then they may be charged a more favourable rate under the loan. Interest can be payable throughout the term or on the final repayment date. As we said before, often with a convertible agreement, interest will actually accrue while the loan remains outstanding. And on conversion, not only will the principal amount of debt convert into shares, the accrued interest will also convert. So the agreement will then move on to talk about repayment. Often loans are stated to be repayable on a sort of long stop or final repayment date. Given the convertible nature, it's more unusual to see that the loan will be repaid in instalments throughout the term of the loan. And the loan will provide that any amounts which have been converted will not fall due for repayment. I mean, that seems obvious, but the position is, your debt either converts or it's repaid. You're not getting the benefit of both. So importantly, the loan agreement will also set out when and how the loan will convert, and we'll come on to more detail on that later. As with a sort of standard loan agreement, the agreement will contain a series of representations, being statements of current or past facts relating to the borrower or its business. And these are often repeated throughout the term of the loan. So what will these go to? These will go to the capacity of the borrower to enter into it. They will go to matters affecting the operation of the borrower's business, the maintenance of its assets. Essentially, what those representations do is they back up any lender due diligence, and they also refresh that throughout the life of the loan. Again, how extensive those are will depend on how well the investor knows the company, what the pre-existing relationship is, and that's really the same with the next clause, which is covenants. So these are undertakings given by a borrower to do or refrain from doing something throughout the term of the loan. Usually we see these divided into sort of three categories, being operational. So how does the borrower operate its business? Information, so information that needs to be delivered to the lender during the life of the loan. And then financial covenants, which are put in place to essentially monitor the financial health of the business and to help ensure that give the lender comfort that the loan will be repaid as stated in the agreement. So in addition to events where the loan may convert, the loan agreement will also include certain events of default, which, if triggered, will allow the lender to call for early repayment of a loan. The circumstances or the events which are included, again, it's a matter for negotiation. There's very standard ones in terms of sort of, for example, non-payment or insolvency events, or they can become quite extensive. And again, it will depend on the relative relationship between the parties. As I said, these agreements can be secured or unsecured. One point just to flag, and it's relevant for coming on to convertible loan notes, is that in the event that you have multiple lenders or multiple note holders, we'd always recommend that a security trustee structure is put in place so that actually the security is granted in favour of a security trustee who holds that security on behalf of the lenders, or in the case of a loan note, the loan note holders. The reason why that is more convenient where you've got multiple lenders is that in the event that any of the debt is assigned or loan notes are transferred to a new lender, they can then accede to the security trustee, and they will take the benefit of the security without you actually having to amend and re-register the underlying security. Or alternatively, were you to have new lenders coming in, if you didn't have a security trust structure, you'd have to put in place new security, which secures that new lender's debt. And also then it would be most likely that you'd put in place a deed of priority in relation to the ranking of the existing security and the new security. So it becomes quite a big sort of administrative process, and it's quite costly. So quite often, if you know you're going to have multiple lenders, multiple loan note holders, it's better to put a security trust structure in place at the start. So moving on to a convertible loan note. So the loan note will be loan notes will be constituted by a loan note instrument, and that will be signed on behalf of the issuer of the loan notes. Loan note holders are not a party to the loan note instrument. They, on subscription for loan notes, will be provided with a loan note certificate, and that evidences the loan notes that have been issued to them. An advantage of a loan note is that the loan notes can very easily be issued to multiple loan note holders. That's kind of what the documentation is set up to do. Equally, if a company knows that it may want to constitute £500,000 of loan notes, for example, but it doesn't necessarily want to issue those all on day one, it can constitute the loan notes and those can be issued over time. The advantage of this over for example, a convertible loan note, where of course it's possible a convertible loan note agreement, where of course it's possible to draw down the loan over time, is that quite often in that scenario, because under a convertible loan agreement, a lender is contractually obliged to lend money, they will actually charge the borrower a commitment fee because they can't go and lend those funds to anyone else, and they're not generating any interest on those funds. They're essentially holding them in reserve to be lent to the borrower at a future point. So in that respect, if you're drawing down over a period of time, possibly a convertible loan agreement, you may incur greater costs than under a convertible loan note. So the loan note instrument itself, that will set out the ranking of the loan notes between all the loan note holders. As standard, this would be the loan notes would rank pari passu and without preference between the note holders. It will also set out, similarly to the loan agreement, the use of proceeds and how the funds are going to be used by the loan note issuer. There'll be provisions relating to the loan note certificates. As I said, the issuer will be obliged to issue a loan note certificate to each person who subscribes for notes. If that loan note certificate is lost or defaced, the instrument will set out the procedure for the issue of replacement certificates. And that's important because at the point those loan notes are redeemed or converted or transferred, the loan note holder will be required to deliver up that certificate before the actual transfer is completed or before funds are, or the time that funds are redeemed. So you want to make sure that you've actually got that certificate, and if anything happens to it, you can get a new one. In the event that there, for example, is a transfer or a conversion and that loan note certificate has been lost and not replaced, it's usual practice that the holder of the loan note would provide an indemnity to the company, essentially indemnifying them for any loss caused by the fact that that loan note certificate is discovered at a later date. The instrument will also include an obligation on the issuer to maintain a loan note register. This is essentially all the details of everyone holding the loan notes, how many they're holding, when they held them, if there's any transfers, it would include a record of those, and that register must be available for inspection by the note holders. It's important that that register's up to date, as in the event that there's any payments due, for example, under the notes, that who those payments are made to will be determined by whose names are in the loan note register as at that date. The instrument will also include issuer covenants and representations. I think it's a general statement. Again, it's subject to negotiation, but usually these are less extensive than in a convertible loan agreement. But importantly, for an investor, they'll want to ensure that the issuer covenants to act in good faith in relation to any proposed exit or any proposed conversion of the loan notes or conversion events. Because the loan note holders are not actually a party to the loan note instrument, but it contains sort of important conditions that the note holders would want to be able to enforce, the instrument will include an enforcement provision which essentially gives those note holders the right to sue and enforce the observance of the terms contained in the loan note instrument. The instrument will also contain a series of what's known as loan note conditions. These will be usually contained in a schedule to the instrument, and these are the conditions on which the loan notes are issued and subject to. They'll cover a whole sort of raft of different things, but sort of importantly, they would normally set out redemption, so when and how the loans may be redeemed or repaid. It'll set out certain trigger events which are not dissimilar to events of default that would trigger immediate redemption. For example, certain insolvency events, if the borrower ceases to trade, if there's a material breach of the terms of the notes and that's not been remedied for a certain number of days. The redemption may be immediate, or it may be at the option of either all note holders or a stated majority of note holders. The conditions will also set out the conversion events, so how and when the notes will be converted into shares and the price in relation to each conversion. Again, similarly to the redemption, conversion may be automatic, or it could be at the option of note holders or a stated note holder majority. If interest is to be charged on the notes, this will be set out again in the conditions. The rate of interest and how interest is to be paid. As we've said, it's more common that interest will accrue and be paid. Either it will be converted with the principal amount of the debt or would be repaid on the final repayment date.
Fee, we should just add on that normally interest under a convertible is simple interest rather than compounded as well.
Yes, yeah, true. And then in terms of if the loan notes may be transferable, and again, that's something to be agreed sort of at the outset in the documentation. The conditions would set out when the notes can be transferred and any conditions relating to the transfer. So it may be that the issuer company says, I'm happy for them to be transferred, but I want to be able to approve any such transfer. It may be that it's, quite often you'll see that it's stated that they can only be transferred in accordance with the articles. Often if there's a shareholders agreement in place in relation to the company, the new loan note holder will have to accede to that shareholders agreement at the point of transfer. And then the conditions will also set out the procedures for note holder meetings. So when can this be held? How can they be convened and conducted? What's the quorum? So i.e. how many loan note holders do you need for a valid meeting? It'll also set out if there's any matters that need to be decided by a special resolution of note holders. So again, this will be a specified majority of note holders. And often the conditions will also state, sort of helpfully from, I guess, an administrative point of view, that a written resolution signed by a stated proportion of note holders will be as valid as a special resolution passed at a meeting. That can be quite useful, if you're looking to amend the terms of the document, of the underlying conditions, for example, of the loan note instrument. You may not actually want to convene a full meeting. So being able to get the shareholder approval through a written resolution is quite a helpful provision. And as I mentioned before, secured or unsecured, and yeah, worth considering putting a security structure in place when a security trustee structure in place where you've got multiple note holders.
So on to the conversion events, this applies whether you use a loan agreement or a loan note instrument. The first one, and certainly the most common, is a qualifying financing round. And by this, we mean that, when the company raises a certain amount of equity investment, and that doesn't have to be from just one person, it can be from one or more people, then conversion would happen automatically. And this is certainly the one that we see in pretty much every convertible, particularly at the moment, because the goal is that the company is going to raise financing in the future. And often investors would want, or investors coming in would want any convertibles to be converted on that date as well. So the company has a cleaner capital table going forward. The other one is the long stop date, which is a maturity date. So rather than repaying the debt could be converted into equity upon maturity. A sale or an exit of the company. So this could be either a share sale, an asset sale, and by that it's a share sale of at least a majority. So one that essentially triggers a change of control, an asset sale of all or materially all of the assets of the company, or a listing, although that doesn't tend to be very common in the companies in which we work. And so on that, the debt would convert immediately prior to an exit. It's always better if that's drafted as an automatic conversion prior to the exit. The reason being that a buyer coming in would want to ensure that it takes a clean company. Oh, that's a good question. Yes.
Hi, Helen, can you hear me?
I can, yes.
Hi, it's James Nichols from Gunner Cook here. Can I just understand that the purpose then of this structure is that the lenders do better by converting to equity because they effectively took it at a discount, so they do better as a result of converting to equity than sticking with their debt?
In a scenario on a sale or an
Well,
exit?
well, yeah. I mean, I can't see why a lender would convert a debt to equity in a liquidate, for example, in a
In a
liquidation.
liquidation, yeah.
Yeah,
So
because they go further down.
Yeah,
They go
I'll come
further
on.
down the capital structure.
Yeah, yeah, exactly. So I'll come on to that one when I get to liquidation.
Yeah.
But I can talk about liquidation now, no problem. So normally you would have events of default, liquidation events. And you're right. If somebody has a convertible instrument, they are debt rather than equity, even if they are an unsecured creditor or an unsecured debt holder, i.e. a creditor. That means that they would take precedent above the shareholders if there was liquidation. Now, sometimes what you see is you see the option that the lender can convert into equity if there is a liquidation event. And the reason why a lender might want to do this is, on a liquidation event, it's very unlikely that an unsecured creditor is going to get anything. However, if they convert into equity, it might be that whatever's happening as part of the liquidation process, the shareholders of the company might be given the opportunity to participate in a new structure. Like, it could be like a pre-pack administration or something. I'm not an insolvency lawyer, so I'm not proposing to go into detail on that in this session, but it just gives them the opportunity to potentially take some shareholding, albeit it might not be worth very much, in a future company.
Can we just take a step back though? Because I mean, I have to admit that I am an insolvency lawyer, but what I'm looking at is from the commercial point of view, the investor does better. I mean, it lends the company money at, I don't know, 8%, but it has this option, or the issuer has the option of making the investor do better by converting to shares. That's the commercial reason for doing it this way, is it?
Yeah, but on a liquidation, it wouldn't necessarily be the company.
Forget liquidation.
Okay.
Imagine somebody's going to buy this company, and by converting their debt into equity, they're proposing that they get the upside of whatever that is in the equity. Yeah.
Exactly. So if we go back to the sale and exit, which is what I was on. So as I was starting to say, the reason why you would want to convert the debt into equity from the company's perspective is because a buyer coming in would normally want to have a clean company that they acquire, and that way they would pay off all the existing shareholders, pay off all the note holders, and so the note holder, the company gets taken as cash free, debt free. That's the goal of a buyer. If we look at the note holder's perspective, their conversion price, I mean, it depends on the commercial agreement in terms of what the conversion price is on an exit. You wouldn't normally offer a discount on an exit. You would normally link the price that they get if they're getting converted on an exit to whatever the valuation of the company is on the exit. So they get their proceeds back. They get they get a portion of the proceeds equivalent to the shares that they would get. So you don't actually issue them shares. It's almost like you do it immediately prior. So it's all very simultaneous.
So do you find that shareholders prior to an event, do they try and look at their refinancing options to avoid triggering the conversion in order to buy off the debt cheaper than buying it off with equity? Do they do that?
The company or
the
note holders?
Yeah, because if you think about it, there's about to be free money around because the investors are owed whatever they lent plus their interest, and on the conversion they are going to get more money. So there's some free money there, but if you pay them off before the conversion, you get to pocket that. I mean, either the shareholders or the buyer or somebody else gets.
Yeah. So normally it would happen on the exit. So you wouldn't normally see a company trying to pay off its convertible if they've got an exit lined up. The reason being, most companies often don't have that cash available to do so. Sometimes they do, but particularly in the way the market's been over the last 18 months or so, it's not happened.
What would a typical facility of this sort of, in using this structure, sort of amount to? Would it be, I mean, 500,000 seems quite, I mean, you know, to do all
depends.
this. Yeah.
It depends. I've got one that's like 2 million at the moment. So,
Yeah.
you know, it very much depends on, you know, how much an investor is willing to invest in the company. You know, so to take some of the convertibles that I've done over the last year, one of them has been for 2 million, which was just from one investor, and that was secured, and that was done by way of a convertible loan agreement. Another was also for a large amount, 1 million, and again done by one investor alone. Others have been for, you know, anywhere between, you know, sort of 200k up to, you know, 5 million, and a variety of investors. It just depends on the company really, and how marketable they are, you know, what their business plan is at the time, and the appetite for investing in them. So you know, the issue that, I mean, one of our clients had an issue. They completed an exit just over a year ago, and they had a convertible. It wasn't actually called a convertible loan agreement, but essentially it was like that. It was a US law governed document, so it was called a convertible promissory note, I believe. But what happened in that structure was because normally when companies are quite cash restricted, they can't, if they're coming up to an exit, they can't necessarily pay the convertible debt off on an exit. Sorry, immediately prior to the exit, they have to use a portion of the proceeds to pay off the debt. Now, what was happening in this scenario, there was no cash available at all in the company. Essentially, there was a small amount, and luckily enough to cover our fees.
That sounds like my situation every time, unfortunately.
Yeah, exactly. Yeah, and it's really tough for companies, and so this particular agreement, the note holders didn't want to convert on an exit. We thought they would do, but they did not want to, and there was no automatic conversion on an exit, which is why, if I'm acting for the company, I often suggest that they have that in there, so it gives it's just easier in terms of kind of doing the structure for the exit. So the note holders were saying, you know, we're keeping the debt outstanding. However, the buyer naturally didn't want to take the company with all this debt in. They wanted the company to be debt free. So what we had to do is we had to essentially novate this debt that was in the company to the sellers on completion. So the sellers assumed the debt on completion, which obviously for the selling shareholders was a bit crap, because they've just got nothing out of the proceeds, because the note holders are getting paid before they get any proceeds. In the long run, there should, you know, if the company does well and the particular assets that they have perform the way that the company hope, then the sellers will get a lot of money. But at the moment, they're not getting that much, because we're just paying off the note holders. We're still doing it now. So yeah.
Okay, that's useful to know. I'm just understanding the commercialities of this structure rather than all the other options.
No, I know
pick
It's
certificates and, you know, all sorts of things?
no, exactly. It's a very good, it's a very good question. And, essentially, it does come down to like the company itself and how much they can negotiate.
Yeah, yeah, yeah. Brilliant.
Um,
Thanks for that. Thank you.
No worries. On the so then we go on to the non-qualifying financing round. So that's if you don't meet the particular threshold for automatic conversion under the qualifying financing round. Sometimes you don't see this, but it's a useful one to have. And often it's at the option of the investors. And if you've got more than one investor in the convertible, then it would be done at the investor majority. And then there's also an investor-friendly one that you can do, which is, at any time the investor majority can opt to convert. And the reason why an investor would want, or the investor majority would want to do that is, they might be looking at the company and its performance, and they might go, well, actually, it's better for us to convert now than in 6 months' time at maturity. So let's do it now, and we'll get a better price. I've already talked about liquidation, so I will move on to conversion prices. Hopefully, no maths questions on this. Although I did do physics A level, but yeah, it was a long time ago. So normally for a qualifying financing round, that would be linked to the subscription price for the round, and often with a discount. Discounts that, as I mentioned, that we see normally sort of between 10 and 20%. 20% seems to be the norm at the moment, and that actually corresponds to the discount rate that you tend to see on safes, which the discount rate tends to be 80% on safes. So well, at least at the moment in the current market. The long stop date, that's normally by reference to a valuation of the company that's agreed at the time at which you enter into the agreement. So the company and the investors would work together on the valuation. They would look at the company's business model and the latest accounts to see what they think is a reasonable valuation. On a sale, again, this is normally linked to the sale on an exit, but it can be linked to a particular valuation. It's a commercial decision really in terms of what gets agreed at that point, and whether the company has an exit in mind, and if they think they can get a particular price for the company at the time that they think they're going to exit. For a non-qualifying financing round, again, that's normally linked to the subscription price for the round, with or without a discount. Again, that's a matter for commercial negotiation. The reason why you offer a discount is because the investors are giving their money now rather than waiting for the round to happen. And so they're taking more risk by giving their money at an earlier stage. Sometimes for a non-qualifying financing round, it is linked to a valuation though, but often it's easier to just link it to the subscription price. Again, I don't need to kind of go through all of these, but yeah, the option for the investor majority, again, that's linked to a particular valuation. Liquidation, this is, a rare one, but again, it could be linked to the valuation at the time of liquidation, which again might not be very much at all. So in terms of valuation caps, so we touched on these briefly before, but these are there to protect investors, and they essentially place a limit on the price at which the convertible debt will become equity. So you might have something that says it's going to be at the subscription price with the discount applied. However, if the valuation of the round is more than the valuation cap, then the valuation will be at the valuation cap. This is taking into account applying the discount. So the reason why you do this, and apologies, I'm probably not making much sense, but the subscription price for the round applied with the discount, if that ends up being a higher amount than what the share price would be with the valuation cap, then you would take the share price with the valuation cap, because that is lower, and that will essentially mean that the investors get more shares than they would if they had the subscription price for the round with the discount. So the investors have certainty in terms of what percentage they're going to get. Hopefully that explains that well enough. Conversion shares, this is normally at the most senior class of shares in issue or to be issued. So it might be that the company only has ordinary shares. So on a sale or an exit, a sale exit of the company, you would get ordinary shares. If it's a qualifying financing round and the company's proposing to put in place shares with a one-time non-participating liquidation preference, then the investor is going to get those shares because they are more senior in terms of a priority.
Okay, just a couple of very quick points on repayment. So in the event that the debt doesn't convert, the instrument will always provide that the debt is to be repaid in full on a stated maturity date, or there may be earlier repayment triggered by the occurrence of an event of default. As I've said, the events of default will be set out in the usual way in the loan agreement. And as I said before, in the event that the debt is converted into equity, that is essentially a deemed repayment of the facility at that point. As I said, you don't get both. You either convert or you repay. And then just a quick note on amendments and waivers under sort of any type of kind of debt instrument. So usually this will provide that amendments need to be made in writing. Where you've got multiple lenders or multiple note holders, usually it will require the company and the note holder majority or the majority lenders to sign the actual formal amendment document. Under a loan agreement, certain provisions may be, certain amendments may only be able to be approved by all lenders. An important point to note is that waivers under the terms of the debt instrument should always be provided that they need to be made in writing. Particularly important with respect to events of default, often a debt instrument and security will give the lender certain rights to do things when an event of default is continuing. As defined, a continuing event of default will be an event of default that hasn't been remedied or waived. Now, as an investor or a lender, what you don't want to happen is that there's any kind of waiver of that event of default by conduct. You want to ensure that an event of default will only be considered waived if a formal waiver has been issued in writing.
Just before we go on to this slide, I see that Georgia actually put a message in the chat. Sorry, I've only just seen it. So when we were talking about the conversion on an exit, she said, presumably it would depend who the note holders are, as if they are existing shareholders, then they'd want to participate in the exit. If the note holders are external, then commercially you may prefer to redeem the CLN rather than let it convert, but often the company won't have the funds to do that. Yeah, exactly, which is what I said. However, sometimes, even if they are existing shareholders, they may not want to participate in the exit, it seems, which is what we had happen on the deal that I was talking about, where we had to novate the debt. I think, you know, as I said, it ultimately depends on the business itself and the reason why these particular note holders, and it wasn't all the existing shareholders, it was just a certain number of existing shareholders. I think they just wanted to be sure that they would get some funds sooner rather than later. And my guess is that, yeah, okay, if they'd converted on an exit, they would end up with a higher percentage of the shares. However, they'd have only got a small portion of the proceeds up front because that was the way in which the consideration was structured. So actually it was better for them to get their debt back by by novating it and getting first stab at the proceeds, so to speak. So questions an investor may ask. We just included these for completeness. I'll quickly whiz through them so that we've got a few minutes for questions. So at what price will my money convert? Well, essentially that depends on what the conversion event is and what the conversion price is, and it should be clearly set out in the relevant agreement. Normally, though, the goal is to convert on a qualifying financing round. So you would be referring the investor to that conversion event because that's ultimately the goal. And say it's normally at a discount to the price per share or a maximum share price, which is where the valuation cap comes in. What if the company becomes insolvent? So again, it depends on the terms of the instrument. Normally, it would be an event of default scenario and they would be treated as debt. However, they could potentially opt to convert into shares if they wanted, but that will depend on the situation at hand. If the company's sold before the shares have been allocated, then they would normally be allocated or deemed allocated just before the funding round. And then they would get the relevant conversion price. Sorry, not before the funding round. They would be deemed allocated just before the sale of the company, and then they'd get the relevant conversion price. What if the amount I've invested is not divisible by the price per share? Then what normally happens is, well, again, like the company could do a subdivision as we talked about earlier, or normally the shares are rounded down so that you get a full number of shares, because obviously we can't issue fractions of shares, and it's always better that that the company has shares that are fully paid for. Sometimes there are adjustment events included in the documentation to allow for a subdivision in the event that one is needed. And again, what class of shares will I be issued? This is the conversion shares. So again, they normally get the most senior class of shares that are in issue upon the occurrence of the conversion event. Okay, any questions? Got 4 minutes left. Okay, we can maybe give people back their 4 minutes.
It's much appreciated. It was very interesting and useful, actually.
Good, very pleased to hear that. Thank you.
Oh.
Yeah, I think the recording will be available, and the slides will also be available as well.
Yeah, could you send the slides, email them to me? I've logged on through LinkedIn, which was impressive, actually. Goodness knows how that actually works. But I think
I have no idea how it works either. So. Somebody more techie than me, but yeah, I'm sure we can arrange for that to happen. I can't remember who's in charge of doing that, but I will make sure it happens.
Brilliant. Okay, thanks guys. Have a nice afternoon.
Bye. Bye.
Bye. Thanks
Thanks everyone.